I'm Teresa Bailey, host of In the Money. On today's show, we're talking about the importance of having updated estate planning documents, which can make life much easier for your heirs when you pass away. Or perhaps more important to you, who has control of your affairs while you are still alive, but unable to make decisions for yourself. According to a 2017 Caring.com survey, only 42% of U.S. adults currently have estate planning documents. For those with children under the age of 18, the figure is even lower, with just 36% having the proper documents. Joining us today is Laura Mason, an attorney with Harkavy, Shainberg, Kaplan, and Dunstan. Laura is going to share with us her thoughts on how estate planning can provide security for your family if you are suddenly unable to care for yourself or your family members. Stay tuned as we sit down to chat with Laura Mason.
You are watching Germantown Municipal Television, your source for everything Germantown.
Today we're discussing how estate planning can factor into protecting your family and your financial plan. Joining us is Memphis attorney Laura Mason. Thank you, Laura, for joining us today.
Thanks for having me. I'm glad to be here.
Well, let's start with if you could tell us a little bit about yourself and what you do every day.
Okay. Well, I am an estate planning and probate administration attorney, which means that I help people both with the planning side of things and also on the after side of things, and in the middle as well. For instance, I'm going to help people draft their documents, get their estate plan in order. I also help people with conservatorships and guardianships, and that is where the probate court is going to oversee the administration of someone's estate while they're still alive. And then, of course, the after side would be after someone passes away. I help the families with the administration of the person's will and or trust.
So I heard a lot of jargon in your answer, which I imagine takes up quite a bit of your time. And that's
Yes.
a little bit, I think what would be great for our viewers today is go through a lot of what you just said and sort of dissect. So in the before stage, when you're really drafting documents and you're looking at documents that can be with them during their lifetime and also after they pass away, what does that relationship look like with a client?
Well, when a new client comes to see me, I want to make sure that the priority is getting them set up with the basic estate planning documents. And so that's going to include a durable general power of attorney, a health care power of attorney, and a living will, which is also sometimes called a Tennessee Advanced Care Plan. The durable general power of attorney, which a lot of people have some vague familiarity with that, but they don't know what all that entails. It can be very tailored for a specific purpose, or it can be broad. And so the most broad version of the document, you are granting someone power to handle your financial, legal, property interests, banking, all of those things for you. And this is a document that takes effect while you're alive. Once you pass away, it's no longer valid.
Okay.
Someone can handle your affairs for you should you be unable to handle them for yourself. Now, with the healthcare power of attorney, that enables someone to speak for you with regard to your healthcare decisions in the event you cannot communicate your wishes yourself, or if you've lost capacity or the ability to make those decisions for yourself.
All right, so you've got two different documents. One grants somebody, I imagine somebody very important in your life.
And someone trustworthy.
Yes, the right to either handle business affairs or health care affairs, and those are two separate documents.
Yes.
Okay, so those are for use while you're alive. Maybe you get in a car wreck, something happens, and you need somebody to step into your place.
Yes, and those are also important for proactive planning because you never know when dementia might strike, and that's a crucial thing to have in place to make your life as well as the lives of those that you care about easier.
So let's say you don't meet with a wonderful attorney like yourself, and dementia does set in. What does that look like if somebody needs to make financial decisions for you and healthcare decisions for you?
Well, when an adult, someone over the age of 18, can no longer make healthcare or financial decisions for themselves, the court is going to have to step in to make sure that that person's best interest and their rights are protected. And so we call that a conservatorship in Tennessee, which means someone is going to have to petition the court for the right to take over those affairs for you. You would likely have to retain an attorney. There's a petition that's filed with the court. There's a hearing that's going to be set. The court most likely appoints a guardian ad litem.
So to interrupt you for a moment, so you're in a hospital bed, so it's not you, it's a loved one.
Yes.
Is that correct?
Yes. So if say John were in a coma and unable to make his decisions, and just to make it easy, say his wife has already passed away and his adult children are trying to make decisions for him, he went into the hospital unexpectedly, one of his children would file a petition with the court, and then a hearing would be set several weeks out probably. Mm-hmm. The guardian ad litem is going to be another local attorney who's appointed by the judge to interview all the interested parties, which is going to be all the immediate family members. And sometimes all the immediate family members agree, sometimes they do not.
Families disagree. You
Yes.
don't say. I'm sure you don't run into that at all.
Right, and so it can be fairly straightforward if all the family members agree, but as you can imagine, when they don't agree and it's contested, the court proceeding can get drug out and become costly as more attorneys are retained and more investigation is required by the court. But ultimately, someone will be appointed to oversee the interests of the person who's lost capacity, which at that point they're called the ward, because
fun.
someone is overseeing their needs. It's also possible that the court could determine the person doesn't need a conservator, but that would just be determined on a factual basis.
So for these documents, it sounds like they're making a decision whether they want their loved ones close by them or in a courtroom.
Yes.
Really preventing them being down at the court office and in the hospital room with them becomes
Right.
sort of the big picture.
Right.
So in addition to the power of attorney documents for health and business, what are some of the other documents really on the initial visit that you're looking through?
Right. The living will, also called the Tennessee Advanced Care Plan, is something where you are making selections in the document itself about your end-of-life choices. And so that can be very useful to your loved ones. Granted, now in a healthcare power of attorney, you are naming someone who can speak for you when you can't communicate for yourself. But when you have the living will where you've made that selection in writing, it generally makes it a lot easier on family members should they be faced with a really tough decision.
That does sound very difficult. That must be a really difficult document to get through with
It
clients.
can be, yes.
I imagine so. We have to take a short break, and we'll be back in a moment with Laura. Stay with us.
Start a story. Adopt at theshelterpetproject.org.
Most party fouls are pretty dumb. But if you decide to drink and drive underage, you could lose your license and your freedom. Underage drinking and driving. The ultimate party foul.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back to In the Money. If you are just joining us, we're talking about estate planning needs for you and your family. Today we're joined by attorney Laura Mason with Harkavy, Shainberg, Kaplan, and Dunstan. So again, Laura, thank you so much for joining us today.
Thanks for having me.
Last segment, we talked a little bit about power of attorney for healthcare, power of attorney for business, and I know that there are, descriptive terms used for that in your industry, but to generalize it, a document for your financial affairs, a document for your healthcare affairs, and then an advance directive template. So I imagine in the next course of conversation with clients, then their last will and testament comes up.
Right.
So what is that conversation like with a client? How do you make the decision which documents and provisions are appropriate?
Well, very frequently with my clients, when they come in for their first initial consultation with me, it is a little bit of an educational session because the clients that are coming to see me are fairly educated and sophisticated. They've done a little bit of research on their own. They know this thing, sort of what a trust is, but they are not sure if they need one, and they want to know the pros and cons. And so I do spend quite a bit of time explaining the differences and the benefits to one versus the other.
And I think that the viewers today would be interested in that. So what is the summary that you usually use between a last will and testament and a trust?
Okay, well, the will is sort of a simpler proposition up front. It's going to be a little bit cheaper to draft up front, but there are definitely pros and cons to it. You get a lot more control if you do a trust. You have a lot more, you can tailor it more in control after the fact, after you pass away. Now, a will is going to require a probate administration at your death, which means your executor, who you name in your will go down to probate court, most likely with an attorney. They will petition the court to have your will admitted, and assuming the court appoints your requested person to be the executor of your will, the executor is then tasked with marshaling the assets, paying any valid creditor claims, and then ultimately distributing the assets to the beneficiaries that have been listed in your will. So the executor has some duties, and the court takes those very seriously, and it's important the executor understands those. So the probate estate has to be open for at least 4 months, so that's not a quick process. During that time, any creditors can file claims if they are owed money from your estate. And one of the duties of the executor is to put any known creditors on notice, to let them know that the probate estate has been opened up. They also have to obtain what's called a release from TennCare, meaning that we have to notify TennCare that an estate has been opened in the decedent's name, and if TennCare paid any monies to for that person's benefit while they're still alive, then TennCare is entitled to be reimbursed out of the estate.
So the executor sounds like a very important person.
It is. It's
What
very important.
characteristics should someone really think about when they're choosing the executor of their will?
Someone who is responsible, organized, good at communicating, because it's an important relationship between the probate attorney and the executor. It's important that they can work together to accomplish these goals that have to be met, the requirements of the court. If you can name someone who lives locally, that's the best, because out-of-state executors are required to post a bond with the court. The bond is sort of like an insurance policy that the court requires you to pay a premium, basically, that's based on the amount of assets in the decedent's estate. So if you're dealing with a sizable estate, your executor is going to have to come up with the premium, and that the amount of the bond is going to be set by the court.
Oh, wow. So if you choose someone who lives here locally and then they move away, you may want to consider revising your document.
Right, absolutely.
Oh, wow. So you mentioned a trust. So talk a little bit about the decision between, do I want a will or do I want a trust?
Okay, a trust, from my experience, clients get a little bit intimidated by a trust until they come and find out a little bit more about it. A trust is a good substitute for a will, and it allows you to set up a trustee. First of all, while you're alive, you are the trustee of your own affairs in a revocable living trust, which is sort of the basic trust we do for people. And then at your death, a successor trustee steps in, and that is someone who you have named in the trust document, and then that person carries out the terms of the trust. And so it's really a seamless process that totally circumvents the probate court if everything works properly and the assets have been titled properly.
Can that person live out of state? Is there an issue?
There's no issue with that. You can name anyone you want.
So if the person that you really trust with making your decisions after you pass away lives out of state, that may be one reason you choose a trust over a standard will.
Yes. Another reason that I'd like to point out would be if you're worried about someone challenging your estate plan, a will is easier to challenge than a trust, because when you probate a will, you're opening an estate with the court, you're providing a forum for someone to go challenge the validity of the will. Whereas with a trust, you're avoiding interacting with the court. And so the burden would be on someone who wants to challenge your trust to go seek court intervention.
So does the trust ever get filed with a court system at all?
No. When you probate a will, it does get filed with the court. It's then public record. Anyone can see it. Whereas with a trust, the trust is a private document that only the beneficiaries are entitled to see.
So if you also wanted to make decisions within your family, it sounds like, if you had maybe one person you wanted to give more to or give to in a different way, but you didn't want everyone to know, then a trust might be an attractive option.
Right, absolutely. You could also have more strings in place to control the distributions to your beneficiaries after your death. We commonly include provisions in a trust for spendthrifts, which is a term we use to describe someone who's not great with handling money. The trustee can have power to dole out money as the beneficiary warrants, and if they're not great with handling money, then that could be very important to control how fast that money gets paid out.
Well, that sounds very interesting. We may come back to that when we come back. We have to take another short break. We'll be right back with Laura.
Of all the things you've done with your bike, donating it to Goodwill may be the most incredible of all. Your donations help fund job placement and training for people in your community, which means your stuff can be more powerful than you think. Goodwill. Donate stuff, create jobs.
How long have we been married there?
For 76 years.
He was kind and generous to me before we married, and he was kind and generous to me all these years. We decided on Meals on Wheels because I was getting to the point where I couldn't do all the things that I had been able to do. We're the Spans. America, let's do lunch.
Drop off a hot meal and say hello. Volunteer by donating your lunch break at americaletsdolunch.org.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back to In the Money. We're talking through estate planning tips for you and your family. Thanks again, Laura, for being here. When we left off, we were talking about spendthrift provisions, which sounds very fancy, but actually it sounds like it's something that might be pretty useful for most families. I imagine hiding amongst most, there's one person you're not quite sure how they're going to handle an inheritance.
Right. It's pretty common that we see that have a client who's concerned about a son or a daughter or even a grandchild blowing through the hard-earned money that the client has accumulated. And so a spendthrift provision is going to be very important in controlling how the money is doled out. Especially if someone has something like a gambling problem, the trustee has discretion to control how that money is going to be distributed to the spendthrift.
So a trust provides you really with quite a bit of control.
Absolutely.
Like. So in trust, I've heard some of the language, some of the viewers out there might have as well, revocable versus irrevocable. Tell us a little bit about those differences.
Okay. A revocable trust, The main purpose is going to be to avoid probate. It is also called an alter ego or a see-through trust. As far as the IRS is concerned, you don't even have a trust. It's identified by your Social Security number. There's no extra tax return required. An irrevocable trust is going to serve the same purpose of avoiding probate, plus an additional goal of which could include tax planning or asset protection.
And so when you set up an irrevocable or irrevocable, I've heard it both ways, trust, why would you, I mean, what are you giving up? What are you gaining? You know, what's the difference?
Well, for those who might be concerned about estate taxes, an irrevocable trust is going to be important for tax planning, because when you set up an irrevocable trust, the assets that you place in that trust are no longer in your estate. And so you're not going to pay estate taxes on those. You give up a certain degree of control, however, and so to a lot of clients, that is a big factor to take into consideration.
So it sounds like you're setting up a completely new being with an irrevocable trust.
Right, absolutely.
So in our last few minutes, I want to dive into maybe some little known estate planning tips or just thoughts from you on what we may need to pay attention to.
Okay, sure. One that we have seen come about more frequently, or we've become more aware of and we're advising our clients, would be to take into consideration when your children turn 18, remember that they are now legal adults and you no longer have the right to make decisions for them. So if your child is getting ready to go off to college or not, it's important to have them sign a healthcare power of attorney and possibly even a durable general power of attorney, so that you, if something were to happen, you can speak on their behalf, you can be an advocate for your child, you can have access to their health information. And if you wanted to assist them with carrying on their banking or other legal matters, those documents would be crucial.
Now, I know every 18-year-old watching this show just thought about their iPhone and their email account and their Instagram. And there's some other things I'm sure I'm not young enough to know yet. But what about technology? If you're giving your parents power of attorney, what all are you giving them power over?
Well, the power of attorney can be as tailored as you want it to be.
Okay.
So the sort of default form that we use that's very broad, your parents could have access to your private information, but you could tailor it so that they don't.
Okay, so you pick and choose which powers your parents want to have if
Yes.
you sign that document.
Yes.
All right, so what about, I know one of the things you and I talked about before the show, house titling and mortgage. I know there's some intricacies there that people may miss from day to day.
Right. I always encourage a husband and wife to own their home as tenants by the entirety, which in Tennessee is a special type of ownership status that's reserved for husbands and wives.
What is the default ownership? Do you
If
have to
you're
request it?
You don't. If you're a husband and wife at the time that you buy the property, the default is tenants by the entirety.
Okay, good.
If you're not married when you buy a piece of property, you will take it either as tenants in common or joint tenants with right of survivorship. The tenants by the entirety, which is reserved for husbands and wives, is sort of the premium way to own property, because it comes with right of survivorship, meaning that when one spouse passes away, the surviving spouse will automatically own the property without any need for additional legal steps. And it also comes with stepped up creditor protections that can benefit the spouse.
And then mortgage situations.
Right. I'm seeing an increase in problems where one spouse passes away, and it happens to be the spouse who was the only one listed on the deed of trust or the mortgage. And then the surviving spouse, although he or she is the sole owner of the property now, the mortgage company won't talk to them because that person is not the one listed on the account. I've even had to take a client to court to get help from the court to force the mortgage company to communicate with my client, which is really mind-boggling if you think about it. So I am encouraging my clients to, even though only one spouse may be on the house note, make sure the other spouse is listed as a person that's, it's okay to communicate with that person about the status of the loan.
Oh, wow. That's such a minor detail that could have such a major impact
I'm
at
getting
a
calls.
horrible time.
I'm getting calls every day about it.
Wow, wow, that's amazing. What about this comes up in my world every once in a while, naming your children as even secondary beneficiaries on accounts.
Absolutely. It's natural to want to name your children as your beneficiaries, but it's important to remember that someone under the age of 18 cannot come into property in their own right. You cannot name a minor as the beneficiary. If you do, we are going to be looking at opening a guardianship with the probate court, where the probate court is going to oversee the money. Someone is going to be named as guardian for the purpose of overseeing that money, and more often than not, the probate court is going to require that the funds be paid into the court's treasury or registry to hold on to until the minor reaches 18 or possibly even older.
Oh, wow. Yeah, that's definitely a small detail that could end tragedy. So you can name them, just know if you do name them, it's going to end up in the court system.
It is, and it's going to cost unnecessary money.
But if perhaps there was no one else and no adult living, then that may be the default.
It could be, or a trust.
A trust. So that situation is really, you want to avoid a minor beneficiary running into that, then you may need to create a trust for that.
Absolutely.
That provision. Okay. And then what about altering estate planning documents? We have just a little bit of time left. What have you seen hiccups in altering documents?
Well, people go to a lot of pains to have their estate plans drawn up, and then they think, oh, I want to make one minor change. I really don't want to go back to the attorney. Let me just make a note on here. And they don't realize that a lot of times that can invalidate your entire document. So it's important, if you want to make a change, call your attorney. A lot of times a small amendment or a codicil to your will can address what you want.
That's important. If you scribble scratch on your original document, it can invalidate the whole thing?
Yes.
Woo, didn't know that. That right there may be worth the whole interview. Thanks for sharing that, Laura. Today, we discussed how proper estate planning can be an important part of protecting your family and their financial plan. Also, that working closely with an attorney like Laura can help you identify which estate planning options are best for you. That's all the time we have today. Thanks to Laura Mason with Harkavy, Shainberg, Kaplan, and Dunstan, and thank you for watching. If you'd like to see more shows, follow us on YouTube or Facebook at Germantown Municipal Television. You can also visit our website at gmtvonline.org. Each person's financial situation is unique. Before making any decisions, please speak to a financial professional to see if our discussions today are in your best interest. We'll see you next month. I'm Teresa Bailey, and now you are in the money.